rights are granted to copyright holders? Just as common law property rights grant owners exclusive powers of possession, use, and distribution, copyright law provides 6 analogous exclusive rights. Copyright law grants a holder the right to reproduce the work, prepare derivative works, distribute copies of the work to the public, perform the work publicly, display the work publicly, perform sound recordings publicly through a digital audio transmission. These rights are exclusive to copyright owners. Only they or those to whom they have legally assigned their rights can act upon them. For example, only the author of a copyrighted book can decide to make copies of or publish the book and creative derivatives of it, such as a movie adaptation. Any other person acting on those rights would infringe the copyright. The term of a copyright varies. For an individual, the term of a copyright is the life of the author plus 70 years. Michael Jackson's vast catalog of original songs, for example, will be protected by copyright until the year 2079 and will certainly be worth many hundreds of billions of dollars to his heirs. For a work with 2 or more authors, the term expires 70 years after the last author's death. Finally, for works that are made for hire or created anonymously, the copyright term lasts 95 years from the first publication or 120 years from the year of the work's creation, whichever comes first. But these lengthy terms for copyright are controversial and considered too long even by many supporters of copyright. What is work for hire? According to U.S. law, a work for hire is a work prepared by an employee within the scope of his or her employment, or a work specifically ordered or commissioned for use as a contribution to a collective work, as part of a motion picture or other audiovisual work, as a translation, as a supplementary work, as a compilation, as an instructional text, as a test, as answer material for a test, or as an atlas, if the parties expressly agree in a written instrument signed by them that the work shall be considered a work made for hire. Under these conditions, work created by an employee or contractor belongs to their employer. What is the first sale doctrine? Authors' distribution rights are strictly limited by what is known as the first sale doctrine, which terminates distribution rights once they sell or distribute the work to someone else. For example, once the author of a copyrighted novel lets his publisher distribute copies of that novel to a bookstore, the author's distribution rights to those copies are ended, and the bookstore can do whatever it wants with those copies. The bookstore owner cannot, however, make additional copies of the book because the first sale doctrine does not limit a copyright owner's reproduction rights. Bobbs-Merrill Company versus Strauss. The first sale doctrine was first laid out in the 1908 Supreme Court case Bobbs-Merrill Company versus Strauss. The Bobbs-Merrill Company distributed copies of a novel titled The Castaway to retailers with a certain proviso. Printed in the book itself, right after the title page, was the following notice. The price of this book at retail is $1 net. No dealer is licensed to sell it at a less price, and a sale at a less price will be treated as an infringement of the copyright. When retailers sold the book for less than $1, the Bobbs-Merrill Company sued one of them. The High Court found that once copies of the book were sold, the distribution rights of the author terminated as to those copies. The ruling came to be known as the first sale doctrine and was codified into law. The statute distinctly draws the line at distribution rights, leaving all other rights to the copyright owner. Werner versus Autodesk. The first sale doctrine does not apply to every form of distribution, however. In the 2010 case Werner versus Autodesk, an appeals court ruled that since purchasers of software are only licensees, software is not subject to the first sale doctrine. What about digital music, such as an iTunes library? In a 2013 case involving the startup company Redigi, U.S. District Court Judge Richard J. Sullivan ruled that a resale of digital music that involved creating a new copy on someone else's computer while erasing the copy on your computer actually concerned the reproduction right, not the distribution right, so the first sale doctrine did not apply. But this decision is likely only the first round in what many feel will ultimately be a successful effort to create legal markets for second-hand digital goods. Moral rights. The first sale doctrine does not affect an author's moral rights, which under U.S. copyright law are limited to certain works of visual art. Under European copyright statutes, however, moral rights are more broadly applied. Is registration necessary? Registration is not required in order to enjoy copyright protection. Once an author puts words to paper, paint to canvas, or software code into a digital file, the work is protected by copyright. Registration of a copyright is recommended, however, because it provides a legal record of ownership in cases where infringement is alleged and is required before the author can file suit for infringement. To register a published work, an author usually needs to submit 2 copies of the work to the U.S. Copyright Office.